thank you all so much for coming today to share this work in progress. I'm presenting this to the faculty on Thursday, so it's your job to tell me what's wrong with it before then. And it's great to have so many familiar faces, some of whom are no doubt here to take revenge and ask me rapid-fire questions that I can't answer, and others to be supportive, and others just to learn some more about constitutional and comparative constitutional law. So my project is basically to take up amendment and look at it in a variety of contexts, and I've been doing research that's empirical. I'm writing a chapter handbook in a handbook that Professor Ginsberger and I are editing about amendment in a comparative context. And this paper is to focus very much on the US and to try and bring those other insights to bear on Article 5 of the US Constitution, which is the formal provision governing amendment in the United States. And I basically have a proposal. I have an argument about the fact that Article 5 is too difficult to satisfy, and I have a novel solution as to how the Supreme Court might go about, at least in part, removing that problem, which is novel and different from some of the folks at Yale Law School's proposal. And I make the case for why it's preferable both on its own terms and also when it comes to potential objections, including objections based on Article 5 itself. So I'm going to focus in my opening remarks on the first three parts of the claim. It's why it's too hard, whether it matters, and my solution. I'll outline some of the objections one might come up with and how I answer them, but I'd love it if you pressed me more on them, and therefore I had the chance to address those more in question time. So Article 5 of the Constitution basically requires that for an amendment to succeed, it needs to get 2/3 of both houses of Congress. There's a convention alternative which in practice has been irrelevant historically in the United States, and that amendments have to be ratified by 3/4 of the states, or either by convention or the legislature. And it's a very onerous requirement in its own terms, and I say it's too hard. Lots of people think it's too hard, and I think there are three reasons you could say that orthodoxy, it's not, there's not consent unanimously about it being too hard, but it's a generally held view, is correct. So the first is just the record of attempts at amendment in the United States. There have been 11,000 proposed amendments in the last 200 years, and as most of you would know, only 27 or maybe 26 of them have actually succeeded. And many of those amendments have actually been extremely popular with national majorities. So a proposed flag burning amendment, a school prayer amendment, amendments to do with DC statehood and a balanced budget, and one which some of you would think that I'd be more predictably enthusiastic about, a gender equality amendment to insert an equal rights guarantee into the 14th Amendment, have all enjoyed clear supermajority, not just ordinary majority support nationally, but have failed at one stage or another under Article 5. So that's the first indicative source of evidence. Can't prove anything, right? It just looks like it's pretty hard in practice even to get amendments with very significant national majority support through the process successfully. The second piece of evidence is comparative. So, again, not definitive, but we would generally think that if the US is a complete outlier in a particular constitutional domain, you'd want to have a good reason for why that's justified. And the US is a complete outlier when it comes to amendment in ways that it's hard to think are justified other than by reference to some kind of Part 2 story which I rebut. So you can figure out how to rank the United States globally in one of two ways. One is you just sit down and you compare 2/3 with 3/4 or 60%. You rank the formal requirements for amendment numerically. And a professor called Donald Lutz did that, and he came up with the conclusion that America was the second hardest constitution in the world to amend after Yugoslavia, right? Which we now know means that America has the hardest constitution in the world to amend. Professor Ginsberg and his co-authors have also done this a different way, and they've said, well, supposing we look at output measures instead, we try and say, well, run rate for amendment relative to number of years in existence or something like that, and they find that on that measure, again, America is a real outlier. which I think is indicative of the fact that it's certainly extremely difficult, in terms of the balance between flexibility and rigidity in global terms. So the third source of evidence, which draws on some of my other work on this area, is historical. And I say, even if you're an originalist, which in constitutional terms means you're more or less committed to giving effect to the original historical purposes or understandings of the Constitution, there's an argument that Article 5 is a lot harder now than it was when it was adopted to satisfy, simply because we have a lot more states and a lot more representatives in the House and in the Senate. And there are two reasons why, as a decision-making body gets bigger, it gets harder to get a supermajority of voters in that body to support a proposal. One is just a process story, right? If we all had to sit down and talk about something, it would take us a lot longer and it would be much more costly in opportunity cost type terms than if, Nancy, Chauncey and I had to decide by a committee of 3. And the second is that if you take a probabilistic view about taking some kind of quasi-random draw of people's views, if bodies like the House and Senate are drawn from the public at large, it gets statistically less likely, as you get a bigger body, that you will find 2/3 of members of the House or the Senate in favour of a particular change if you think that the median voter is more or less agnostic. So there's a law of large numbers reason that means that as you get bigger bodies, they converge towards, in a sense, being agnostic in the way that the population might be, and therefore it's much harder to get amendments through. So I have an empirical piece elsewhere about that, and I'm happy to take questions, but the basic argument is bigger bodies, harder to get something through, which means that even from a historical originalist perspective, there's an argument that Article 5 is too hard. So does it matter? Well, Professor Strauss says no, right? He has a really famous piece in the Harvard Law Review that says the irrelevance of constitutional amendments. Other professors at Stanford and Yale have written a piece that says, well, in the US, it doesn't matter because of statutes. And Professor Strauss and the super statute guys together basically have an argument that says, well, forget Article 5 and what we might call capital C constitutional change, right? Change to the text of the Constitution. Doesn't matter because most change gets done in America in a small c constitutional way, via statute and via the common law. So at any time there's any sort of broad support to update the Constitution's meaning, the court does it. And if the court doesn't do it, Congress will do it. So just don't worry about this stupid Article 5 nonsense, right? And I said, look, Professor Strauss/Eskridge and Ferrajon have a pretty good point in general, but not when it comes to a small but democratically significant subset of cases where the court in particular chooses to update constitutional meaning in a way that a majority of Americans acting reasonably just doesn't agree with, right? Think abortion, think aspects of Roe v. Wade, and think the flag burning controversy in Texas v. Johnson. That's one part of the story which I call clearly counter-majoritarian decisions. The other set of decisions are decisions where it's perhaps less headline grabbing, but the court also blocks small c constitutional change by stopping Congress from doing the kind of statute making that allows for this kind of change. Think here of Morrison striking down the Violence Against Women Act. Think Bernie v. Flores striking down the Religious Freedom Restoration Act. In these cases, I say, disagreement about the meaning of the Constitution is reasonable, and I hope some of you will attack me on that. And if Congress and state legislatures can't push back on the court, we have a democratic problem. That's what Article 5, in a sense, is meant to be a placeholder for, a commitment that in the ultimate analysis there is scope for democratic input in our constitutional system when it comes to judgments about values where we disagree. And if it doesn't work, there's a real problem because it's much, much harder for Congress and state legislatures successfully to override the court. Amendments help them override in 3 different ways. One is by enabling some judges who would otherwise be willing to take that step towards overruling a prior deeply unpopular counter-majoritarian precedent to feel legally and politically justified in doing so. And the second and third way they do it is by encouraging judges who would otherwise stick to their guns to go in that direction because of the weight of the textual, historical and prudential support that an amendment can provide for overruling a prior decision. And in the shadow of that direct kind of here's an amendment, you know, you better back down, the threat of amendment also creates a very powerful set of incentives or encouragement for judges to defer to attempts by Congress or state legislatures to meet them halfway, right? Which is, I call that the idea of ordinary legislative dialogue or dialogic legislative sequels. And if you have the threat of complete override via amendment, courts have much more powerful reason to defer to that kind of legislation than if there's no credible threat of override via amendment. Critics will say, well, you know, it's not only amendment, Dixon, that's going to provide this kind of enabling or encouraging function. There are other ways that you can get around court decisions you don't like, including in the United States via Congress's power to suspend certain kinds of jurisdiction or make exceptions to the Supreme Court's jurisdiction in Article 3. But I really don't think that you can see that as equivalent either in terms of the actual history of it being used, it hasn't been, right, almost ever, and in terms of its actual incentive properties. The final answer people, or argument people make in the, oh, but it's irrelevant context is, well, you know, in the long run, the President and the Senate, you know, get to nominate and advise and consent on the justices, and you change the court, and that's how you override really, really democratically unpopular court decisions in America. But, you know, my response to that is the one that John Maynard Keynes gave to the monetarists, which is, in the long run, we are all dead. And in the medium term, it matters, right? Which is, democracy is not a 20 to 50 year project. It's a much more immediate, medium-term project. And while we might want deliberation, we might not want to, you know, react the day after 9/11 in passing the Patriot Act. We don't need 20 years or 50 years to have that kind of appropriate deliberation or slowing down effect. So what's my proposal? The proposal is that the Supreme Court itself should help lower the bar to successful invocation of Article 5 by recognising what I call a principle of partial constitutional amendment, which means proposed and failed amendments, as well as successful ones, should be given some degree of legal force by the Supreme Court. The only amendments that I'm willing to treat as plausible candidates for the principle are those that can get majority support in Congress, maybe implied, but probably actual majority support. And then above that, you could think of them as divided in roughly 3 buckets in terms of their degree of persuasive force. The lowest level would be just proposals that get majority support. The next bucket would be those that can get supermajority support in Congress and or some degree of support from the states. You know, if it doesn't get to 2/3, it won't go to ratification, but states have often passed sort of sympathetic resolutions, as they did in the flag burning context. So the middle bucket is some mix of more than majority support either in the states or in Congress. And the third is almost successful, majority state support and supermajority congressional support in much the same way you saw for the Equal Rights Amendment. And I said, if you think about dividing the positive legal force of amendments in this way, you should think about them as having the status, in legal terms, as more or less equivalent to a persuasive judicial precedent. So the idea is the court pre-commits itself, or some members of the court pre-commit themselves to saying, when Congress can get close, we will treat that as if it's an intervening persuasive precedent in deciding whether to revisit our prior precedents. The way that would work in overcoming the difficulty we currently face under Article 5 is that it would provide a legally recognised source of legal support for a decision to overrule a prior counter-majoritarian or blocking decision. And so the logic of how it would work is much the same way we think successful amendments work. They provide legal support for a decision which to override or overrule, which enables some judges, the judges who want to do it anyway, to feel legally and politically justified in overruling a prior counter-majoritarian decision, or slightly weaker, sure, but still real encouragement for other justices to revisit prior precedents in order to make way for counter-legislative trends or legislative attempts at redirection of constitutional meaning. I say there's some precedent for this approach. It's a novel idea. There's no court or country that does it, but there are two indirect sources of precedent or support. One is the US itself, which is when the Supreme Court has hard cases under the 8th Amendment about cruel and unusual punishment, or under the Due Process Clause of the 14th Amendment about the meaning of liberty in an evolving sense. It looks to state-level legislative trends and congressional trends and says, oh, look, this has some evidentiary value in figuring out what constitutional provisions mean. And I said, that's basically just giving ordinary majority-supported legislation constitutional status. Evidentiary status, sure, but it's a form of constitutional status. And this is simply extending that to give it legal status. And the second source of precedent comes from India, and it inverts an approach developed by the Supreme Court of India in the context of Article 368 of the Indian Constitution. So in India, they have the absolute opposite problems to America, which is it's too easy to amend the Constitution. So, you know, the Constitution is hundreds of pages long. There are literally, you know, over 100 amendments, and there's a widespread understanding that amendment has been overused by the Congress Party and particularly by Prime Minister Indira Gandhi during the emergency to entrench power, to override civil liberties, and to pursue partisan ends. And so the court in India developed what it called a basic structure approach, i.e. amendments cannot override the basic structure of the Indian Constitution. Prior to that, they said they couldn't even override contrary other provisions in the Constitution. And I said, if you go back and you look at India and you map what the court's done onto what got support in the Lok Sabha initially, there's a direct correlation between how much political support there was for an amendment above a majority threshold and how much force the court was willing to give the amendment. And I said, flip that to in America and you say, right, according to how much force, how much support a proposed amendment gets, it could get a corresponding degree or variable degree of legal force up and to the point where it has full effect, where it meets the requirements of Article 5. There are three potential objections. One is, well, what about Article 5? Isn't that supposed to be the process for amendment? And I said, well, sure. But this doesn't purport to add or subtract from the text of the Constitution. It says we're providing a precedent-like principle, which alters the interpretation of the Constitution and not its text. And in any event, if you think, why was Article 5 in there in the first place? Well, part of it was about democracy, and part of it was about federalism and deliberation. And if the idea is federalism matters, certain kind of democratic deliberation matters, my proposal is better than either the status quo, the Straussian, just let the Supreme Court do it, or the Yale version, which is it should be legitimate for there to be a national referendum as an alternative to Article 5. And I said, look, if you think about either the text or the values it was designed to serve, my proposal is much more satisfactory than the Yale alternative or the status quo. If you're worried about minority rights protection, that's a real objection. There are basically two prongs to my answer. One is, if national majorities that are mobilised strongly oppose the recognition of a particular right, the Supreme Court can't do anything effective to protect those rights. That is the lesson of school busing. It is the lesson of parts of the Roe decision. Professor Rosenberg has done a much better job than I could possibly in making that case, as has Professor Kleiman at Harvard. And I just build on them and say, if it truly national majorities oppose minority rights protection, there's no hope of effective judicial review anyway. That doesn't mean there's not a more modest but still important pro-dialogic function that courts can play, but this kind of principle is not going to get in the way of it. And so the kind of review that courts can do that works is not going to be impaired. Finally, people might say, well, you know, you have this whole idea that courts are going to be encouraged, if some justices commit themselves to this principle, to defer to legislative attempts at dialogue. Maybe, but there's also this danger that on the contrary, they will say, well, unless there's Article 5 engaged, we're not deferring. And so there's some sort of negative inference dynamic gets set up, and I make things worse, not better. Well, first of all, I just don't think I'm going to be that successful in my idea that that dynamic is going to be established anytime soon. The sort of justices who are likely to like this idea are not committed to the kind of mechanical exclusio unius negative inference type dynamic that would be necessary for that logic to apply. And my last response is, well, okay, imagine that did happen. I don't think it would be so terrible from a democratic perspective for two reasons. One is, I'm only saying you need ordinary majority support in Congress for the principle to apply. And so that is not that different from a world in which you can get majority support for an ordinary piece of legislation. And secondly, there's good evidence to suggest, well, I can't say it's good because, I helped prove it, but there's some evidence to suggest that amendment is path dependent, right? The more you amend, the easier it is to amend at a state level in the US. So if we kind of reinvigorate Article 5 in some way, we'll make it easier to rely on in the future. And so that the path dependence argument helps answer any concern of that kind. So that's the idea. It's still in progress, and now I would love your thoughts, questions, and suggestions. Zach?
Two unrelated questions. One is, if you do this, then every single law that's passed by definition has majoritarian support.
Yep.
So how, I guess that...
There'd be a formal naming requirement, right? You'd have to invoke it as the nomenclature of amendment.
Okay.
And there's very good precedent for that, which is one of the sources of evidence I give in my article about why we think it does matter that it's so hard is if you compare Canada and the United States and you look at the record of the court here versus across the border in cases where they get a piece of legislation back, right? The legislature tries to chip away and it comes back. The US court is much less deferential than the Canadian court. And I say one of the reasons for that is there's a provision in the Canadian Charter called Section 33 of the Canadian Charter, which is an amendment-like power, very flexible, that helps pressure the Canadian court to do it. But clearly they have to use, when the Parliament is going to use that provision, they have to say so, right? That's all. It's ordinary majority, but they do have to say, just to be clear, guys, we're relying on Section 33. So there would have to be a labelling requirement.
Okay.
Second question.
The other question was, what effects do you think this would have on the types of judges, justices that get nominated?
None. I think that you have to give me sort of multiple versions of reality, right? Which is this is like an uber successful principle that, finds majority recognition on the court. I think it might mean, if that sort of alternate universe, that presidents might be slightly less worried about ideological litmus tests for justices because the court as a whole would be committed to a principle that would force it to retreat or put pressure on it to retreat in the face of information that it was being strongly counter-majoritarian. The easier it is to override what judges do, right? The less worried you are in principle about what they do ex ante. But I don't think that you could imagine it having that effect, in part because this is a reasonably modest solution because it leaves things in the hands of judges in a way that says, listen, you should pre-commit yourself to this principle, but we do understand that you still have flexibility as to how much weight you give it. Janling?
I'm just wondering how much is this proposal different from what's already happening? Because as you say, it's like the justices who will be inclined to accept this approach is already those who are more liberal will adopt the living constitution standard.
Okay, so this is a great question, which is, I think that there's a way I could have written this paper that says, here's my idea and the court already does it, okay? But I think that's only the case vis-a-vis what you might call jump-starting decisions or decisions where amendments are designed to encourage the court to develop and update the Constitution. So, for instance, in the context of the Equal Rights Amendment, proposed in 1972, right, defeated in 1981, beginning of 1982, the court after that does almost everything, not everything, almost everything the Equal Rights Amendment would have done via interpretation. And so Professor Strauss says, what are we upset about, really? And I think that is pretty powerful as an argument where the court is responding to majoritarian trends. But my argument is liberal, whatever you want to call people, when, you know, people get a decision where they get information about having really got it wrong about whatever Americans' views are, right? Justice Blackmun in Roe v. Wade went much, much more broadly than most Americans were favoured vis-a-vis abortion. There's good public opinion data to suggest that most Americans do favour a limited abortion right, but not an unlimited abortion right. And in faced with that information in 1982 in Akron, in 1986 in Thornburg, in 1989 in Webster, the Liberal justices all said public opinion, legislative trends, irrelevant, right? Same in relation to flag burning. 1989, the court in Texas v. Johnson hands down a decision, 5-4, the Liberal justices in the majority, saying it's unconstitutional for Texas to prohibit the burning of the flag. The Congress steps in, modifies the prohibition a little bit, enacts the Flag Protection Act of 1989, comes back before the court in 1990, Eichmann v. United States, the Liberal justices strike it down. So I don't think that in areas of pushback that you already see this principle at work. Follow up.
But let me just push back more. Because you say that this is just only a persuasive argument.
Right.
So your example that this principle doesn't work, I don't think it's strong, it's self-conclusive evidence that we need this partial constitutional amendment, but rather simply that even if this amendment has been in play,
right.
this procedure has been in place, the Liberal justices would find it, find it persuasive, but ultimately not persuaded.
Okay, so I mean, this friendly amendment I'm willing to take, which is to say, so now Jalen's saying, look, you can't tell that they're not doing it. It's just because it's not always decisive, right? It can be persuasive without being decisive. So they waited in Akron and Thornburg and, particularly in Eichmann, but they just thought everything else came out the other way. Possible, but so what? It just means that I'm now arguing for a principle that is implicit or imminent in existing Supreme Court practice. And, as Professor, some of you've heard this before, but as Professor Larry Tribe says about Lawrence v. Texas, the fundamental right that dare not speak its name. Now it's the principle of partial amendment that dare not speak its name, right? Supreme Court's been doing it. It's time for them to come out in the open. Marcy.
I'm sort of worried about trickle-down effects before these cases get to the Supreme Court, and that there would be mass confusion about what the law actually was after the amendment reaches this partial stage.
Right.
So how do you sort of communicate before a case reaches the Supreme Court of what standards or what new policies should be implemented at a lower level?
So there could be two versions of your question, right? What poor federal district court judges, that's version one, and two is poor citizens, right? Which is, there's some principle here about pushback and how extensive is it, what happens. So I think in relation to both, my answer is similar, although not identical. The answer is basically we already have significant confusion in instances where legislatures are committed to pushing back, because there is some chance that what they do will be upheld, and we just don't know exactly how strong that chance is. The other variation is in the relation to federal district courts. In general, if it's unclear, there's pretty good evidence that they tend to just do what they think is the right answer, right? So in some parts of the country, Roe was relaxed much more readily than it was in other parts of the country, and that this doesn't really alter that significantly. But I think the other part of it is that, over time, as the court applies this more frequently, you would get some sense of the ability to predict how decisive is this likely to be. Is the mere passage, right, at time 2 of an Article 5 named ordinary statute, how much reliance should we place on it? So I guess the answer is, it's a good point. It's a real argument. I've had to answer versions of this argument in the context of concerns about dialogue more generally in Canada, and I think it's a good one. But the two answers is we already live with it, and over time things would get more predictable in ways that would mean that you had some sense of how it would play out. And if Jalen's right, which is to some extent courts do respond one way or another to democratic pressure, it might provide a little bit more predictability by being transparent about when and how much.
Yeah, I wonder what this kind of a process might do to the ability of the court to resist majoritarian opinion when it ought to do so. I mean, the founders seem to have been as wary of the tyranny of a majority as of the tyranny of one or two, and an overly easy amendment process might lead to things like in California, where 51% were able to pass the Proposition 8. So are there rights or principles which we would want to protect against 51%, and would that speak against the ease of the amendment process?
So, this is a great point, both because, it's one I have to answer and it also helps me explain where I stand better, right? So, one is, you're exactly right, which is this theory depends on there being reasonable disagreement about the meaning of the Constitution's guarantees. And if there is no scope for reasonable disagreement, right, and there's a minority involved, we really want the court to stand up for the minority against the majority and say, it might be nice, it might be convenient, it might make you sleep safer at night, but it's not what we are committed to as a constitutional democracy. But I just think that the scope for reasonable disagreement is much broader than you probably do, or that we were taught to believe in, Government 101, which is most of these questions. I'm not someone who would legislate to ban flag burning, and I quite like abortion rights. But I do think that there is scope for reasonable disagreement among people of, different religious and comprehensive viewpoints, and that we should take it very seriously when there is disagreement of that kind. And for the court to say, we've figured it out, that exactly what the Constitution means when it comes to an abstract guarantee like Congress shall make no law regarding the freedom of speech, or liberty shall not be deprived without due process. And that means at 23 weeks you can't have a pro-life counselling requirement. I think there's scope for reasonable disagreement. Now, the version of the response to me is to say, well, if there's some core area where the courts should be pro-minority, and then this other area where I think they should be willing to be more open to dialogue with democratic opinion, provided it's reasonable. You say, well, there's slippage, right? You're now going to have justices who are wimps because they're pre-committing themselves to always deferring to majoritarian sentiment, and that's possible. I mean, there are good institutional structures to mean that courts are insulated in those extreme cases from the need to defer. And the principle's not so strong that it would require them to do so. It might encourage it, but in a case of pretty extreme violation, you could imagine conscience and other factors pushing in the opposite direction. And the other response, which I think goes to your California Prop 8 example, is if one of the things we think that courts can most usefully do vis-a-vis minority rights is push the ball forward, right? Come and say, look, civil unions aren't good enough. Let's have a conversation in California about whether we aren't really at a moment where we can recognise full dignity and equality. I think courts are empowered to do that by the knowledge that they can be overridden, which is, California's is an unfortunate result, but I don't think you would have got the first California opinion without the possibility of override under Prop 8 style amendment, and you won't see it in the United States for a while, in part because of Article 5. So I think it can have an empowering effect in some number of cases ex ante that's really positive. But, we disagree. I think more rights are open to disagreement, reasonable disagreement, than you do, and that's definitely a premise of the theory. There and then the back, yeah.
I was just wondering, Article 5 tends to insulate the courts from partisan politics.
Right.
I mean, that's its goal. How would this continue the goal of insulation from partisan politics? I mean, because you say you need a 50% or a supermajority. So the Republicans sweep in the 94. They pass a whole swath of these partial constitutional amendments, and then there's this time where people don't really like them, but they're still persuasive on the courts. People can't overturn them.
Okay, so let me.
And then you lose a partisan. One party that no longer has power, and then a different party comes in. How does it work?
So, two answers. One is I think we should distinguish between the court is insulated from sort of direct interference from partisan politics by the structure of Article 3, right? Our biggest fear is that President Bush can ring up, you know, one of his appointees and instruct that person how to vote or threaten that, etc. You get the idea. So that essentially, I don't think that the primary guarantee of independence from the most partisan form of interference is Article 5, it's Article 3. Lifetime tenure, no removal except for just cause, no diminution in terms of, etc. That's our most core commitment when it comes to judicial independence. And countries that have, you know, 50% of amendment rules still manage to deal with that kind of core protection from partisan interference. But when it comes to partisan politics, all you're really saying is ordinary politics, right? Which is sometimes the Republicans do well and sometimes the Democrats do well. And how do we feel about a constitutional law that reflects those changes more quickly or more in sync with those prevailing democratic views than in a delayed way, right? 20 years later, it turns out that there was, you know, a switch, and now the Republicans, long after having lost office, are now influencing the court, and vice versa, right? If Obama gets to appoint some justices long after, you know, the Republicans have reinstalled in the White House, you know, you'll have now Democratic justices doing the opposite on the court. So, look, I think it's a good argument which says we do want some counter-majoritarian forces operating within our system, but we live in a system of divided government, right? The presidency and the Congress are often held, at least in part of the president's term, by different parties. That in itself is a cross-cutting force. There is going to be diversity within the court in terms of how we appoint our judges, and I just don't think it would be such a terrible thing if constitutional law changed more, right? So sometimes constitutional law would be more protective of abortion rights and sometimes less so, within a fairly narrowed bound, right? Because this is just a persuasive principle that says, you really got this wrong and, you know, you really got this right, and it's not going to be just flipping every time. The other thing is Americans don't like their representatives to tamper with the Constitution, right? And so by merely using the Article 5 word, as a legislator, you are saying, look, I feel this intensely, right? I'm not just voting my political agenda on healthcare, I'm voting something as a matter of principle, and I think that as a result, you wouldn't expect this kind of procedure, process to get going in areas where there wasn't some degree of bipartisan support. And you know, you think about flag burning, you think about school prayer, think about equal rights. These are both issues where you can identify one party as more in favour than the other, but there was you know, cross-party support for all of those, and I think you'd expect that to more or less continue because of the check of the word Article 5. You know, not that powerful, but you know, still real, and I don't think you would see the kind of wild swings either both because of the weight of the principle and also just the internal check on its use. In the back.
Yeah, I'm wondering if you have a federalism concern, because it enables people to bypass the second half of Article 5 where the states have a direct role.
Yeah, I mean, so look, I actually say in the objections that it's better, which is it's certainly better than a national referendum, right, where the states count for 0. And if you take account of the, you know, what's the status quo? Well, the status quo is Supreme Court gets to decide what the Constitution means without any formal ability for anyone to override them. There used to be a much stronger norm of regional representation on the Supreme Court than there currently is, right? There is not a southern seat on the court at the moment in the way there used to be. You know, presidents probably do care a little bit about geographic representation in appointing to the court, but not much. So that if the status quo is the court decides and state legislatures and Congress have to have, you know, take their chances, it's not looking very good for federalism as it is, right? And so part of what I say is, okay, you know, relative to the status quo is either Congress succeeds or state legislatures succeed in pushing back against the court without any invocation of Article 5 or supporting principles, in which case no change. This is designed to simply support that kind of willingness to show dialogue in cases of reasonable disagreement and pushback on the part of legislatures, or add an additional mechanism. And in this mechanism, not on bucket 1, right, majority supported enactments. But whenever bucket 2 or bucket 3, i.e. heightened persuasiveness, is because of state support. And so it says, right, it's not a mandatory consideration of state legislative views or interests, but it's definitely allowing a pretty clear avenue for state input in ways that certainly the status quo doesn't allow very readily, and most other theories don't either. So it's a good point, but I think that you have to say relative to what, because let's be clear, it's not relative to Article 5 function in exactly the way you would expect, which is every 10 years or so there's a successful amendment, right? It's relative to a circumstance in which it's almost never used, and therefore the court and Congress, and occasionally state legislatures get their way, or let's do something, completely anti-federalist, like have a national referendum. Maya, and then, sorry, you were first. Can you just say me your name? David, and then Maya. Yeah.
I guess I'd like to hear more about why you think that 20 to 30 year time frame for amendment is bad. I mean,
Yep.
Our union has been around for over 200 years. People in this classroom, 23, they embark on a 3-year process at law school to better themselves, and that's about the same ratio.
Right.
Why is a 20 to 30 year time frame necessarily a bad thing to fundamentally alter the structure of our nation?
Right. I mean, I think this is a good question because there's no kind of precise answer to it, right? How long should it take? We can't kind of agree on some numerical sort of golden rule of what's optimal. We can only have a rough heuristic about too short and too long. I think most people would agree, really rapid constitutional change without any adequate time for either public consideration of all relevant information, and secondly, cooling off of certain kinds of passions or checking of certain deliberative biases in the behavioural law and economic sense. That's too short, okay? But I don't think you can say that 6 to 12 months isn't long enough to do that. So then you say, well, what's gained by taking 20 years rather than a year? You say, well, one is we just protect certain really fundamental values, and that's really important. Well, I'm saying the whole point is you're not protecting fundamental values, you're protecting what a majority of the Supreme Court and a minority of the country think is fundamental, and what a majority of Congress and many state legislatures and most Americans think is not fundamental, like, you can burn the flag without any fear of criminal penalty, and you are free of waiting periods in the 23rd week of pregnancy if you want an abortion. Whether I agree with them, you agree with them, it doesn't mean that they're kind of fundamental, enduring values, right? They're aspects that are highly contested and which are being contested in the meantime. So to say that there's some stability, there's contestation going on, they haven't necessarily predated the Supreme Court judgment, they may not survive anyway, it's not clear exactly that you're protecting anything that we could call fundamental or enduring in any event. And then thirdly, I guess, would be the point of you saying to me, well, I just think constitutional stability is a really good thing, right? As between dynamism and stability, I like stability. And that's unanswerable, which is if you come down firmly on the view that stability is really important as a primary value rather than the extent to which Americans think the Constitution reflects their values, the extent to which they see the Constitution as a document that unifies them as a site of identity formation, the extent to which the document and its interpretive practices help create a legitimacy for a government that executes people, puts people in Guantanamo, requires people to do all sorts of other acts of quite significant sacrifice or restriction on personal liberty. Stability over legitimacy, you win, absolutely. And so it's a contested judgment, right? And I'm totally on board that it's a line drawing exercise. I just think that from 1973 to 1982 on abortion was not helpful and not justified on any kind of really robust theory of deliberation, rather than just really slow change can be good. Now, 3 out of 20 years, I'm glad you're spending 3 years at law school. It's definitely a judgment call, but it's one that I think that while people could differ, on reflection, it's hard to defend the length of delay that we have for the kinds of issues we do, right? Maya?
This is a little bit left field, but I'm just wondering what sorts of repercussions the amendments might have on international views on the limits.
Yeah, this is a fun question. It's a very speculative question. One view is people wouldn't care, right? America can just do whatever it wants. The second is that if you take my answer to, your name? Doug, seriously, right, which is that you lower the threshold for reversal somewhat, you empower courts to be a little bit more experimental. America might have a bit more to say to the rest of the world relative to what it currently does, right, which is there are lots of constitutional courts doing experimental things that the Supreme Court doesn't feel able to do or doesn't want to do. And if it's the part that's about able, not wanting, might join the conversation, the global conversation more. Certainly, there are numerous reasons why the US Supreme Court has been very influential historically and lost influence in the last 10 to 15 years. And this is not the only one, but you could imagine that this would have some impact. And then the third way in which I could imagine it being relevant, although I doubt it, but it's possible, is the US is pretty influential when it comes to exporting constitutional design principles, right? So those of you in my comparative constitutional law class have heard this a few times, but the recent efforts in Kenya to draft a constitution, the same in Iraq, the same in Afghanistan, there's a lot of American expertise that gets exported to that kind of context. And the American orthodoxy is hard amendment is good, right? And if there's a sort of internal recognition that overly hard amendment is not so good, and there are ways of sort of lowering it without totally sort of sacrificing some of the commitments to minority protection or deliberation, right? There might be, so it's not that you would write this into another constitution, but more that America and leading American constitutional thinkers such as its Supreme Court justices would be seen as endorsing the idea that you don't want to make amendment too hard. Behind Connor, and then Connor. So your name?
Nick. I have two parts. At first, in terms of just your empirical question, I think your picture sort of looks at the federal constitution and sort of misses the fact that we do have a very, I would at least say, too robust state amendment process.
Highly flexible, shall we say? Right. Sure.
And how do you just take that? I don't know. I don't think that the cantons of Switzerland, for example, tend to amend their constitutions particularly rapidly, and it's pretty easy to amend, their constitution, or Germany, or how does that compare empirically?
So this is a good question. So Professor Ginsberg and Professor Posner have a paper that they're currently writing called Subconstitutionalism that looks at state-level constitutions, and one of the things they look at is its amendment rules, and they say, well, you could imagine that it would be optimal to have somewhat harder amendment at a national level and somewhat easier at a state level, experiments, lower agency costs. There's this overlay of the national to protect the state, which is one of the reasons I think, while I'm troubled by Prop 8, I do think still the sort of fear it raises of outright mob legislation is diminished because of the protection provided by the Federal Equal Protection Clause. So, okay, so there's a complementary relationship between the two, and you could imagine a story that says there's some argument when you have a federal system for slightly easier amendment at a state level, slightly harder at a national level. I don't think I'm suggesting that we're going to have majority amendment at a national level, right? So there's still a pretty significant gap between you can persuade the Supreme Court to give weak persuasive value to a majority supported amendment at a national level, and you can have X thousand signatures and you can get popular initiative override. So there's a spectrum here. So I would embrace the point as there should be a wedge, right? We should think of one as more flexible than the other, but I think by bringing this one down just a tiny bit closer, I'm not bringing it anywhere like close enough, too close. And I think secondly, there's two potential problems with a model that leaves all of the experimentation to get done at a state level. One is the instability problem, okay, which is if states have very different amendment rules, but they are doing things that have spillover effects, like people moving once they get married, there is a degree to which the issue's going to get pushed up. And having a state level system which allows for a lot of flexibility, but then a national system that once the issue's pushed up nationally, it is really hard to resolve and override. Hard, that's a problem, it's an instability problem. The second is you've got to ask yourself, how many issues do you want to be issues of pure state concern versus national federal concern? Because it changes the nature of the polity you live in, right? And America has, at least post-Civil War, been a polity that is committed to a certain notion of shared national values. And so if that's right, I mean, I'm agnostic about that question, but if that's right, then you can't have too big a separation. You can't make the federal too hard, because you cannot keep issues of core national concern at a state level indefinitely, because from a normative matter, not just an instability, predictive matter, they have to come up, right? At some point you say segregation is not a matter of local concern, it's a matter of national concern, it's about our shared national values. And, and it's very conceivable that gay rights will get to that moment in the next, 2 years, 10 years, 20 years, and that at that point the federal rule starts to really kick in about institutional responsibility for defining national values. Follow up, Nick.
Follow up to that is, and I say this as someone, having been very involved in early, decisions about, do we bring marriage litigation?
Yeah.
And the first thing we look at is, can the populace override it? Because the normative effect of, we came within 2 votes of losing Massachusetts, and I can tell you, had we lost Massachusetts, we would not have gone to, we would not have gone into Iowa, we would not have gone into New York,
right.
We would not have gone, anywhere else. And there is this immediate blowback that I think courts worry about, and it's something that we, from a normative perspective, look to try to survive. And I don't think we would see courts like Massachusetts taking the chance. And I think the real issue is, how do you get a decision like Massachusetts, which sort of creates a normative effect for the nation? In other words, we have this trend where, because of these few standout decisions, it allows the rest of the populace to sort of, it allows the court to sort of, a few courts to sort of lead and the rest of the populace to follow. And we think that, that's how this social change is happening.
Right.
It could not possibly happen any other way. It's how, miscegenation laws were gotten rid of, and it's how the 19th Amendment eventually.
So, anti-miscegenation laws were taken off the books in a slightly different way, in that Loving v. Virginia came in 1967, right? 13 years after Brown, and a long time after most states had taken these off their books. So it was it was much less experimentalist and much more about mopping up states that hadn't got with a national identity program than Goodridge, which was much more experimentalist, right? It's saying we're a blue state and we have a vision of justice and equality and we're going to try it out and see what happens. My answer to the amendment point, which is, you're threatening Goodridge, is I think, and I can't prove, because I've tried to look at the abortion data at state level and tried to look at same-sex relationship cases at a state level, but there are just too few data points, right? You cannot run robust regressions with 12 or 14 data points. Is that it looks like this, which is, if amendment is too easy, courts are not going to experiment and litigants aren't going to bring the cases because they know that, it's going to be overridden. If it's too hard, they also won't bring it, because the fear is, as I said in response to Doug, courts will be really, really cautious. It's the middle, right, where it's hard but not impossible, where courts are likely to feel, well, we have a view about what the public thinks, we're not sure what the majority thinks, we have a view about what's right as a matter of the text and constitutional morality, and we'll have a go. Worst case, they override us. It's not that likely. And, it's not like we're being philosopher kings locking in our views for eternity or, half a generation. And so we'll have a go. So my view is Massachusetts right in the middle. There's a double passage requirement. You've got to go to an electorate. It's not. If you rank state amendments, it's about 1/3. And then you've got to control for the fact that it's very blue until recently. Connor.
I'm just wondering whether the availability of partial amendments would actually decrease the likelihood of formal ones. So you could foresee the possibility of an interest group trying to push an amendment.
Right.
They get it through Congress, and then they have to justify again trying to get it formalized. Because people might just say, well, you've already got a sort of partial amendment, why just not settle for that? And it might actually sort of decrease the pressure that you need to get full change.
So I could imagine that if there was a court decision after just Congress, people might stop, right? We got there. Why do we care, right? We persuaded that we had our partial principle, the court recognized it, we're done. That's totally plausible. Now assume that the court hasn't ruled, you've just got it through Congress, right? I think part of the answer to that is, well, the danger of resting on your laurels is then it comes before the court and the court says, well, it's weakly persuasive but not that persuasive. The court then reaffirms its prior precedent and it then becomes really much harder to persuade them. So that one of the things is, you know, obviously the more courts affirm decisions, the harder it is to persuade them to overrule. You know, to the point that Nick made about the selection of Perry, like, it's not neutral for a court to reject a challenge, right? It cements the prior status quo. So it would be a very brave, you know, set of public, of interest groups to say, just forget it. I think you're right that it might lead to fewer completely successful amendments in that before you got state ratification, the Supreme Court would recognise it and it would go away as an issue. But I think you'd get the idea that you would stop before the Supreme Court, you know, took that path seems unlikely. I also make an argument in the paper that it goes exactly the opposite way, which is when the ERA was pending, Justice Powell in particular said, I don't want to do aggressive, robust gender equality review because let the democratic process go its way. And there's a way in which some of the judges, contra Janlins, have suggested, you know, whether something can get support at an amendment is relevant to whether the court should do parallel work. And I think it's a powerful disincentive to ever invoking Article 5, which is chances of succeeding under Article 5, you know, not knowing enough about the specifics, less than 0.25%. Right? Chances of persuading the Supreme Court of something which, you know, quite a lot of people agree with, 1 in 3. And you take your 1 in 3 down quite a lot if you invoke some unsuccessful process under the status quo, right? So I think the status quo, which basically says it's expensive, you're just absolutely not going to win, and, you know, you're much better off trying to persuade the court, or maybe Congress without the court, suggests that it flips the incentives in a good way. Right? But I definitely take the point that says once amendments are sort of in process, so proposed amendments that are still in process and the court takes up the principle, it diminishes the incentive for further effort. But I can see one response is you'd have to have an incredibly formalist conception of democracy for that to matter, that someone didn't get to, you know, in Rhode Island deliberate about it further in ways, you know, that we should care about. And the second is, I think the view that says, oh, it would really matter to sort of cement that change in the text itself creates too undynamic a view of how constitutional meaning gets done in the US, right? Just because you write it down after this successful process doesn't guarantee that it will last as, you know, longer or more broadly or more significantly in the future. It certainly is more powerful in the particular case, right? But once the Supreme Court's done what you wanted them to do, it's overdetermined. And as for like the next case, 10 years on, 20 years on, who knows? And the text by itself doesn't tell you anything. We know that, in particular, as David Strauss has shown, and, you know, I've done some other research about it, it's about the 19th Amendment, right? The 19th Amendment was meant to be the women's rights amendment, and it did just, you know, it did the women's right to vote in a certain kind of federalism way, and then nothing more. Nothing, right? So the fact that it was in the text, and one of the arguments that I've made is that part of that is it was so hard to get the 19th Amendment through that all the real feminist types who were like, this is about women's equality, had to shut up and say, this is just about a very limited issue, which is, you know, you can still carry a parasol and have a right to vote. So when it came to issues about, you know, the role of women, and they were like, well, there's nothing to suggest that there's anything contrary in the 19th Amendment. You know, women can be excused from jury duty because that was just about voting, not about equal citizenship, right? And so there's an endogeneity to the rule, which means that how much change you have matters. I'm going to finish up in 2 or 3 minutes, Ben. So 2 more questions.
Is there a worry about wasted legislative resources with, so if an amendment fails right now, they can just ignore it, they don't have to worry about an impact on the court, but if there were partial constitutional amendments...
I'm suggesting that's not right, which is that the fear is you say, well, you know, we tried with the Equal Rights Amendment and we failed, and some judges, like Powell, might say, well, you know, that says something about national majority opinion, and if, to the extent that we do take into account majority opinion, it doesn't help make the case for heightened scrutiny by the Supreme Court. Now, not all the judges do that, sure, but I'm saying it's definitely an available inference for some justices, and there's some suggestion that some of them, like Powell in Frontiero, think it might be a valid approach.
I guess the worry is that the legislature feeling that it needs to provide contrary persuasive authority,
Okay.
Which seems like it might be a complete waste if it didn't pass in the first place. Why should they feel the need to do this? And if this becomes fairly common, they might need to do it a considerable amount.
So this was I think this is the negative inference point, right? It says at the moment, some number of times Congress or state legislatures pushes back on the court without mentioning Article 5, right? And it succeeds. So for instance, if you go back and you look at what happened between 1992, where the Supreme Court in RAV and St. Paul struck down St. Paul's hate speech ordinance, and then Virginia v. Black in 2003, where the Supreme Court upholds a different anti-cross burning law in Pennsylvania. There are about 10 states that push back against the Supreme Court's opinion. The Supreme Court doesn't mention that. It's not litigated very explicitly, but it's clear that everyone was like, yeah, we actually kind of want to ban hate speech, and I know you said we can't, but we're going to come up with some very limited exceptions that push back, and the court upholds it. So your worry is Virginia v. Black is now, you know, decided differently next time once this principle gets recognised. I think, is that right?
I'm worried that they'll feel that they need to try to pass a law to counteract a law they didn't pass in the first place, so that now there's persuasive authority on the books to show the court that they didn't really mean it the first time, or that they no longer mean it.
Okay, so the argument is now not so much about overriding, it's about some other form of interpretation. And I think the part is, then your point is something like this, which is, I'm directing this principle at the idea of override or redirection, right? And that might have some negative spillover on the court's willingness to initiate change, a la equal protection and gender. I think that's right. No? I don't think number one happens almost ever. In America, courts, for good reason, don't like opinion polls. And so absent legislative pushback, the sort of democratic change doesn't happen. And so that all I think that the resource point is, some more legislatures might have to pass supporting resolutions to make the Article 5 label work, or they have to use a label. I just don't see that the resource point as being significantly different. Okay, so that's us. Thank you very much.